This current trial's case brief presentation examines the case of the Crown, which is represented by the letter R, against Stillwell. The case was heard in 2014 by the Court of Appeal for Ontario. Facts. March 31, 2011, Christopher Stillwell, the respondent, was charged one count of each accessing, possessing, and distributing child pornography. 26 months passed between the date the charges were laid and June 7, 2013, the date of the respondent's trial. The respondent then applied for a stay of proceedings, complaining that his right to a trial within a reasonable time under Section 11B of the Canadian Charter of Rights and Freedoms had been violated. Section 11, Proceedings in Criminal and Penal Matters, states that any person charged with an offense has the right to be tried within a reasonable time. The respondent also complained that he had suffered prejudice. The judge of the trial decided that 12.5 months of delay was attributable to the Crown and held that this delay exceeded the approximate window of 8 to 10 months which were set out in R v. Morin in 1992 by the Supreme Court reports. The trial judge also finds the delay was in part due to prejudice towards the respondent. Thus, the trial judge enters a stay of proceedings. The Crown appeals. First, by justifying that the delay was reasonable due to the fact that the large number of pornographic files on the respondent's computer required careful examination and categorization. Second, the Crown also argues that the trial judge had made an error in assessing the prejudice to Stillwell. Issue 1. The trial judge finds that the respondent's right to trial within a reasonable time had been infringed, and therefore enters a stay of proceedings. Should the Court of Appeal accept the Crown's grounds for appeal? 2. The trial judge finds that respondent had suffered actual prejudice by having to wait so long to have his charges determined, and therefore enters a stay of proceedings. Should the Court of Appeal accept the Crown's grounds for appeal? Decision. The Court's appeal is allowed, and the matter must therefore proceed to trial. Rationale. Issue 1. Before the Court of Appeal, the Crown argues that the allocation of delay should go as follows. Intake period, which is neutral, for 9 months, defense conduct for 8.5 months, unexpected leave of officer in charge should be allocated 2.5 months, which is neutral, and the institutional delay of 6.5 months should also be accounted. The Court accepts the intake period of 9 months, meaning the time of investigation, to be neutral, and thus reasonable on the grounds that the use of technology lends itself to thorough investigation because of the huge number of files that must be investigated. The Court accepts the attribution of the 5.5-month delay of the defense because the defense only looked at the final report in August of 2012, even though it was ready in June of 2012, and the trial date was not even selected until November of that year. The Court accepts the extra delay regarding the unexpected leave of absence of the officer in charge, and therefore accepts the additional 2.5 months it took to find a suitable replacement. The Court does not, however, accept the appeal of the Crown on the grounds of 5.5 months of delay, and therefore agrees with the decision of the trial judge because the Crown herself caused this as she failed to ascertain the police's progress with the report. Therefore, most periods of delay have been justified, except for a period of 5.5 months. When the justified delay is added to the unreasonable delay, the total is 12.5 months. Though this is beyond the Morin guideline of 8 to 10 months, it is not exceedingly so, and is therefore considered, though not ideal, not unreasonable by the Court of Appeal. Rationale, Issue 2. The Court of Appeal finds that though the trial judge was not mistaken in finding some prejudice, the Court holds that she severely underemphasized the seriousness of the charges against the respondent. Additionally, it was found by the trial judge that the respondent had suffered personal prejudice because he could not socialize with friends, family, and coworkers in the fear that children may be present. In fact, this was found to be false by the Court, as the respondent was not prohibited to engage in all social interactions as long as they were age-appropriate activities. Thus, the Court held the Crown's appeal and therefore rejects the trial judge's conclusion that the respondent had suffered enough prejudice for a stay of proceedings to be entered. Conclusion of both issues. Given the delay period did not exceed the Morin guideline by a lot, and that the respondent was only subject to minor prejudice, the Court allowed the analysis. R v. Stillwell provides us with a significant outlook regarding the balancing required between prejudice to the respondent and the ever-present stigma that surrounds child pornography. When involved with a case that deals with matter as serious as child pornography, it is easy to forget the rights of the accused, which in this case are the right to a trial within reasonable time. The recent Spencer 2014 Supreme Court of Canada decision tells us a little more about this. Society undoubtedly has an interest in seeing a full and fair trial based on reliable evidence, and all the more so for a crime which implicates the safety of children. From this case, it can also be known that minimal prejudice does not warrant a stay. Survey question. Do you think the court's decision to allow the Crown's appeal was justified, and the trial judge had it wrong? Yes or no?